I'm Jonathan Reed, and I've been practicing immigration law in California for 18 years. In that time, I've seen some desperate situations, but few compared to the frantic call I received on a Tuesday morning, a call that set in motion a race against the clock to save a family from being torn apart forever. The voice on the other end was Maria, my client's sister, breathless, hysterical. "They're taking her, Jonathan. She's at the detention center. They're putting her on a flight tonight. Please, you have to do something." My stomach dropped. Maria Rodriguez, a devoted mother of 2 American children, was literally hours away from being deported. We'd fought her case for months, even years, trying to reverse an old removal order, but the government had finally moved to execute it. This wasn't just another case. This was a life-or-death situation for a family, the very last gasp before an irreversible separation. I first met Maria 6 months earlier in my bustling Los Angeles office. She walked in, her shoulders hunched, eyes red-rimmed and swollen from silent tears. She carried a worn plastic folder filled with a jumble of papers, each one a testament to years of struggle and misunderstanding within the labyrinthine immigration system. Her story, as it unfolded, was heartbreakingly common, but with a twist that made my blood run cold. She had revealed, almost as an afterthought, that her youngest child, a bright-eyed 8-year-old girl named Sophia, suffered from a rare congenital heart defect. Sophia required constant, specialized medical care that was only available here in the United States. This wasn't just about Maria's future, it was about Sophia's very survival. That detail, whispered in a breaking voice, confirmed for me that this was a battle I absolutely had to win. The stakes weren't just a green card or a new life. They were a child's heartbeat, a mother's embrace, and a family's fundamental right to exist together. Here's what you need to understand about the legal framework governing situations like Maria's. When someone faces deportation, legally termed removal, they often look for relief, something that allows them to stay in the United States despite having an immigration violation. One of the most challenging forms of relief to obtain is what's known as cancellation of removal for non-permanent residents. Under Title 8 of the United States Code, Section 1289B, each one, often referred to as IAT CNA, Tikra 240A B1. An individual who is not a lawful permanent resident can apply for cancellation of removal if they can demonstrate several things. First, they must have been continuously physically present in the U.S. for at least 10 years immediately preceding the date of their application. Maria met that requirement. Second, they must be a person of good moral character. Maria, with no criminal record and a history of hard work, certainly fit that description. Third, and this is where the bar is set incredibly high, they must prove that their removal would result in exceptional and extremely unusual hardship to a qualifying relative, such as a U.S. citizen spouse, parent, or child. This isn't just hardship, mind you. It's a profound, devastating level of difficulty that goes far beyond what any family might normally experience upon separation or relocation. The government's perspective is that any deportation creates hardship. The challenge is to prove that your family's specific hardship is exceptional and extremely unusual. This is the critical juncture where most cases falter, and it's precisely why Maria's previous attempts had failed. The law demands compelling, undeniable evidence that the qualifying relative's life would be irrevocably harmed without the applicant's presence. Maria Rodriguez was 41 years old when she first walked into my office. Her resilience etched onto her face, but her spirit clearly battered. She had come to the United States from Central America in 2002 on a tourist visa, drawn by the promise of better opportunities. She'd overstayed, as many do, but she wasn't a criminal. She was simply trying to survive and build a life. She married a U.S. citizen, Marco, in 2008, a kind, hard-working man she met through their local church in San Bernardino. Together, they built a small but loving family, welcoming their first child Isabella in 2009, and then little Sophia in 2012. Maria worked tirelessly as a seamstress for a local garment factory, her nimble fingers producing clothes that would eventually end up in high-end boutiques, while Marco worked construction. Their life was modest but full of love. Her legal troubles began in 2015, after an unfortunately timed traffic stop led to an encounter with immigration officials. Her name was flagged and she soon received a notice to appear, NTA, in immigration court. At that point, Marco had filed an I-130 petition for alien relative for her, hoping to legalize her status through marriage. But the process was slow and complicated. She hired a low-cost immigration attorney, Mr. Sanchez, who promised to handle everything. What followed was a Kafkaesque nightmare of missed deadlines, unfiled documents, and a complete lack of communication from her previous counsel. Mr. Sanchez, it turned out, was overwhelmed, disorganized, and ultimately incompetent. The immigration judge, Judge Ramirez, had issued a removal order against Maria in 2021, finding that she hadn't met the exceptional and extremely unusual hardship threshold, primarily because the critical medical records for Sophia were never properly presented. Maria had tried to appeal, but her previous attorney botched that too. When she came to me, the removal order was final, and she was simply waiting for the inevitable, living under the dark cloud of impending separation. Her previous legal efforts had not only failed but had painted a picture of a case already lost. Marco, her husband, stood by her side, equally distraught but with a quiet strength, urging her to fight one last time for their family. I looked at Maria's defeated eyes, then at Marco's determined gaze, and knew I couldn't turn them away. The vulnerability of their situation, especially Sophia's life-threatening condition, resonated deeply within me. This wasn't just a legal challenge, it was a moral imperative. My investigative phase began with a deep dive into Maria's entire immigration history. I requested every single document from the USCIS and immigration court files, a process that itself took weeks. I pored over transcripts from her previous hearings, cross-referencing them with the sparse filings from Mr. Sanchez. It was immediately clear that vital information was missing. The previous attorney had made a perfunctory effort, but it was far from what was needed for such a high-stakes case. The clock was ticking, not just because Maria had a final order of removal, but because ICE was notoriously unpredictable in when they would execute such orders. My first strategic move was to secure a comprehensive, up-to-date medical evaluation for Sophia. I brought in Dr. Evelyn Hayes, a renowned pediatric cardiologist from Children's Hospital Los Angeles, known for her meticulous reports and compelling testimony. She specialized in rare congenital heart diseases, and her initial assessment confirmed my worst fears. Sophia's condition was delicate, requiring not just medication but precise, ongoing monitoring and, potentially, emergency interventions that demanded state-of-the-art facilities and a highly specialized medical team. Dr. Hayes' report detailed the specific medications, diagnostic tools, and surgical options available in California that were simply non-existent in Maria's home country. Meanwhile, my paralegal, Sarah, and I began the painstaking process of reconstructing Maria's life in the U.S. We gathered every scrap of evidence proving her continuous presence and good moral character, school records for her children, utility bills spanning 15 years, bank statements, employment verification letters, affidavits from neighbors, teachers, and church members. We even dug into her social media, finding photos and posts that documented her life here. It was like piecing together a vast, complicated puzzle with many missing parts. The opposition, the Assistant Chief Counsel for Immigration and Customs Enforcement, Michael Thompson, was a formidable adversary. I knew Thompson by reputation, sharp, experienced, and utterly unyielding. He rarely granted concessions, his primary objective always being to uphold the government's position. This meant any motion to reopen Maria's case would be met with fierce resistance. He would argue that Maria had her chance, that she'd failed to meet the burden, and that any new evidence could have been presented earlier. We hit several dead ends. The records from Mr. Sanchez's office were almost non-existent. He'd since retired and was unresponsive to our inquiries, clearly trying to avoid any scrutiny of his past work. I feared we wouldn't find the definitive smoking gun to prove ineffective assistance of counsel. But I wasn't done. I instructed Maria and Marco to go through every single piece of paper they had ever received, no matter how insignificant it seemed. Weeks went by. Then, late one night, a breakthrough. Maria called me, her voice trembling with a mix of exhaustion and dawning hope. She had found a box of old papers in the back of their closet, tucked away, forgotten. Among them was an official-looking letter from the Immigration Court, dated back to 2017, clearly addressed to Mr. Sanchez. The letter stated in no uncertain terms that the medical records pertaining to Sophia's heart condition were insufficient, and that additional, detailed documentation was required for a proper assessment of hardship. This was the evidence I needed. My heart raced when I saw that letter. It was an official court communication, explicitly asking for the very medical records that were crucial to Maria's case, the records Mr. Sanchez had failed to submit. And right there, nestled in that same forgotten box, were the original, detailed diagnostic reports from Sophia's early childhood, the very documents the court had requested and never received. These weren't just new records, these were records that existed, at the time of her original hearing, records that were requested by the court, and records that were inexplicably withheld by her previous counsel. This was the smoking gun. This wasn't just poor representation. This was a clear, undeniable case of ineffective assistance of counsel, violating Maria's due process rights to a fair hearing. The legal significance was immense. It allowed us to file a motion to reopen proceedings based on ineffective assistance of counsel, arguing that Maria was deprived of a fair opportunity to present her claim for cancellation of removal due to her previous attorney's egregious errors. This wasn't just about proving hardship. It was about proving the system had failed her, and that she deserved a second chance. When I called Maria with the news, her initial reaction was a stunned silence, then a raw, guttural sob of relief that echoed in my ear. "Dios mío," she kept repeating. "My God." It was the first glimmer of true hope she'd had in years. With the newly unearthed evidence, I immediately filed an emergency motion to stay Maria's removal and to reopen her cancellation of removal proceedings. The government, as expected, opposed it fiercely. They argued that Maria had ample opportunity to present her case, that new evidence should not be allowed after a final order, and that the exceptional and extremely unusual hardship standard remained unmet. The hearing for our emergency motion was scheduled for the very morning of the day she was set to be deported. The atmosphere in Immigration Court, located in downtown Los Angeles, was always tense, but on that particular Tuesday it felt suffocating. Judge Elena Ramirez presided, a fair but no-nonsense judge known for her meticulous attention to detail and her impatience for unprepared attorneys. The courtroom was packed, not with spectators for our case, but with other desperate families awaiting their own fates. Assistant Chief Counsel Michael Thompson, ever the picture of unwavering confidence, sat across from me at the opposing counsel's table. He nodded curtly, his expression grim. Maria sat beside me, her hands clasped tightly in her lap, her face pale. This was her last stand. I called Dr. Evelyn Hayes as my key witness. Her testimony was powerful, painting a stark clinical picture of Sophia's fragile health. Dr. Hayes, calm and authoritative, explained the intricate details of Sophia's congenital heart condition, the delicate balance of medications required, and the high risk of catastrophic events without immediate access to a specialized emergency room. She described the specific, highly specialized cardiac procedures that were only performed in advanced medical centers like those in Los Angeles, and unequivocally stated that Sophia's chances of survival and quality of life would plummet dramatically if she were removed to Maria's home country, where such medical infrastructure simply did not exist. "It is not an exaggeration to say, Your Honor," Dr. Hayes concluded, looking directly at Judge Ramirez, "that without her mother present to advocate for her, and without access to the specific care she receives here, Sophia's life would be in grave danger." Thompson's cross-examination of Dr. Hayes was aggressive. "Dr. Hayes," he began, "are you aware of every medical facility in Maria's home country?" "No, Mr. Thompson," she replied evenly, "but I am aware of the standard of care for pediatric cardiology in that region, and it is significantly below what Sophia requires." He pressed on, attempting to minimize the hardship, suggesting that Maria's other U.S. citizen child, Isabella, could care for Sophia, or that Marco, the father, would be sufficient. Each attempt to chip away at the exceptional hardship was met with my objections, most of which Judge Ramirez sustained. Then it was my turn to address the court. I didn't waste time. "Your Honor," I began, my voice clear and steady, The government claims that Maria had her chance. They claim that the hardship to her U.S. citizen children does not meet the exceptional and extremely unusual standard. But what the government fails to acknowledge, what they could not acknowledge, is that Maria was deprived of the fundamental right to present her case fairly in the first place. I held up the official court letter I'd found in Maria's forgotten box. This letter, dated 2017, explicitly requested additional, detailed medical documentation for Sophia's heart condition, documentation that was absolutely critical for assessing the hardship claim. This letter was sent to her previous counsel, Mr. Sanchez. I then displayed the stack of comprehensive medical reports from Sophia's treating physicians, dating back years, the very documents requested. These documents, Your Honor, existed. They were available. But they were never submitted. They were never presented to this court. I watched Thompson's face. The usual confident smirk had drained, replaced by a visible tension around his jaw. He knew. This wasn't just new evidence. This was proof of a systemic failure, an undeniable instance of ineffective assistance of counsel. I continued, detailing Mr. Sanchez's pattern of negligence, showing how he had missed filing deadlines and failed to submit crucial evidence, effectively sabotaging Maria's case. This was not a failure of Maria to prove hardship, Your Honor, I concluded, my voice rising slightly. This was a failure of due process. She never truly had her day in court. Judge Ramirez leaned back, her gaze moving between the documents, Thompson and me. The courtroom was silent, every single person holding their breath. The tension was almost unbearable. The wait for the judge's ruling felt like an eternity. Judge Ramirez looked from the documents I had presented to Michael Thompson, whose usual confident posture had visibly slumped. The sheer weight of the evidence, particularly the court's own prior communication explicitly requesting the missing medical records, was undeniable. Finally, she straightened, her voice cutting through the suffocating silence. "Mr. Reed," she began, "your motion to reopen proceedings based on ineffective assistance of counsel has presented compelling evidence. The court finds that Ms. Rodriguez was demonstrably prejudiced by her previous counsel's failure to submit critical documentation, specifically the detailed medical records for her daughter, Sophia. This deprived her of a fair opportunity to present her claim for cancellation of removal." A gasp escaped Maria's lips beside me. Judge Ramirez continued, "Therefore, I am granting the motion to stay removal and the motion to reopen Ms. Rodriguez's case. Her removal order is vacated, and she will be granted a new hearing to present her full case for cancellation of removal." The gavel struck, a sharp, decisive sound that echoed like a final victory bell. Maria dissolved into tears, burying her face in her hands, her shoulders shaking with an overwhelming mix of relief and disbelief. Marco immediately pulled her into a tight embrace, whispering, "Gracias a Dios," over and over. Michael Thompson, usually composed, merely nodded, his face unreadable but his shoulders clearly slumped in defeat. He'd fought hard, but the truth, backed by irrefutable evidence, had prevailed. The specific outcome was monumental. Maria was not deported that day. She was released from detention later that afternoon, walking out into the California sunshine as a free woman, at least for now. Her removal order, which had hung over her for years, was gone. We had bought her time, a second chance, a real opportunity to win her fight to stay with her children. Over the next few months, we diligently prepared for her new hearing, resubmitting all the evidence, including the powerful medical report from Dr. Hayes and detailed affidavits from her children and community. 7 months later, after a thorough review, Judge Ramirez officially granted Maria Rodriguez cancellation of removal. She was finally, legally, a lawful, permanent resident. The nightmare was over. Here's what I learned from this case. Never, ever give up, and never assume that the existing record tells the whole story. Maria's case was technically closed, and the government was ready to deport her. But by digging deep, by refusing to accept the surface-level narrative, we found the key to unlocking a new path. This case wasn't just about the law, it was about exposing the failures of the system and the dire consequences of inadequate representation. The broader legal lesson for anyone watching is profoundly important. The immigration system is unforgiving. It's designed to be a complex maze, and without competent, dedicated counsel, even the most deserving individuals can be lost within it. The warning signs in Maria's story are stark. If your attorney isn't communicating with you, if you don't receive copies of every document filed on your behalf, or if you feel rushed and unheard, those are bright red flags. Always ask questions, demand transparency, and never be afraid to seek a second opinion. Practical advice: if you're facing deportation or any serious immigration matter, the single most important thing you can do is find an experienced, ethical immigration attorney. Do your research, check their reputation, and ensure they specialize in the kind of case you have. Don't trust your future to someone who seems overwhelmed or disinterested. This case, like so many others, revealed the sheer desperation people experience when their lives, their families, and their futures hang in the balance. It showed me the immense power of hope, even when all seems lost, and the profound responsibility we, as attorneys, carry to be the last line of defense for those who have nowhere else to turn. Today, Maria is a green card holder, a legal permanent resident of the United States. She's still working as a seamstress, but now with a lightness in her step and a peace she hadn't known in years. Isabella is excelling in school, and Sophia, thanks to the continued specialized care she receives, is thriving, her heart condition stable and well managed. They just went on their first family vacation together, a trip to the Grand Canyon, a dream Maria had held onto for nearly 2 decades. Knowing that I played a part in keeping that family together, in literally saving Sophia's life by ensuring she remained in a place where she could receive proper medical care, is why I do this job. It's why I dedicate my life to these battles. If you have questions about immigration law, or if you've had an experience that sounds similar to Maria's, drop your questions in the comments below. I'm here to shed light on these complex issues, and I've got plenty more stories of last-minute saves and hard-won battles to share. Stay tuned.